in disproportionate cases, my lord, 17A is not applicable. No doubt he said that when the FIR, it is stated that during his tenure, yes, he misusing his power and misusing his government official position, my lord, he accumulated some disproportionate assets, my lord, which is not, my lord, in his, my lord, the discharge of his official functions, my lord. Because 17A is clear, my lord, the alleged offense is relatable to any recommendation made or a decision taken by a public servant in discharge of his official function or duties. The the assets which is accumulated during his tenure of service, my lord, it is not his, my lord, the discharge of his official functions, my lord. That's why, my lord, 17A is not applicable. It is clear from the, my lord, Dhandapani case and, my lord, the state of, my lord, Kerala, where it's clearly, my lord, stated that, my lord, the Sankara, what, my lord, into these two cases, my lord, these two high courts is very much clear that 17A is not applicable in disproportionate cases, and very elaborately, my lord, in Kerala High Court, in Sankara Bhat, my lord, in para 13, 14, 15, 16, 17, 18, 19, 21, 22, 23, 24, 25, 26, elaborately discussed, my lord, how it's will not come. And moreover, my lord, the Supreme Court, my lord, recent judgment, the Nara Subramaniam Swamy, where, my lord, there are two views, my lord. There is no any judgments or order has been passed. There are two views taken by the, my lord, the Aniruddha Bose, my lord, in Nara Chandrababu Naidu cases, my lord, is purely on corruption case, my lord. In paragraph 3, it clearly says that primarily the allegation against the applicant facilitating the diversion of public money. Here, my lord, public money has been diversion and it was corrupted, and actually raises 370 crores. It is direct, this is corruption case. Here, my lord, the Aniruddha Bose, Justice Aniruddha Bose, in his order, my lord, in paragraph 34, in paragraph 5, here it's, my lord, clearly says, as per the investigation authority, a sum of rupees 370 crores from the government fund of APCD has been siphoned off. Here clearly a corruption case, my lord. It's not, my lord, the compare with this present case, my lord, because there is a distinction. Here is a corruption case, and here is, my lord, a disproportionate assets case. And moreover, in paragraph 34, the Honorable Justice Aniruddha Bose says, at least prima facie in discharge of his official duty, there is a prima facie found in the said official duty, he has corrupted the said money. That's why he said, well, the prior, the discharge of his duty, previous approval of authority postulated in subsection ABC, section 17A of Act shall be to be obtained. And other view, my lord, taken by the Trivedi, Honorable Justice Trivedi, in paragraph 12, 13, 20 to 25 and 28, where he taken a view that the 17A would not be applicable in the offense of PC Act amendment by the so-and-so Act 2000. And that's why, my lord, there are two views. That's why it's sent to the larger bench. But in the said judgment, nowhere it has been stated that the cases where 17A has not been taken, that matter should be stayed or that should not be going on. That there is no such order has been. There are two views. That there are descending views. That's why it was sent to the larger bench. It was pending for Supreme Court, and it's purely a corruption case. But here in this case, a disproportionate assets case. And Kerala High Court and Madras High Court in Dhandapani case, and it's clearly said that the 17A is not applicable in disproportionate cases. That is my humble submission before also. And regarding the, if 17A is not required, the question of approval prior or beyond is, which does not come, my lord, in this case.
Then why the approval, my lord? First thing comes there.
But the thing is that approval is taken here.
My lord, yes. Though, my lord, approval is taken here, but law is settled, my lord. The 17A is not applicable. Rightly, wrongly, my lord, the investigating officer has taken approval. But question is that, my lord, law is settled, my lord, 17A is not applicable. If not applicable, question of, my lord, approval beyond, my lord, the prior, it's not come, my lord, in this case.
My lord,
it doesn't mean that, my lord, investigation is doing some error. The law is, my lord, my lord, follow this, my lord, the IO investigations, my lord, which was doing, my lord,
may I, my lord?
Yes.
The phrase is under this act, my lord. In the statute book, it is very clear that under this act, any offense which has to be committed. So, when we evaluate this particular phrase, my lord, then the entire kind of offenses which obviously do not require any instantaneous arrest, my lord, would fall under this category. So, that being said, my lord, 17A was inserted in the said act because of the purpose of protection of a public servant. in today's date, my lord, if approval as such is not required, as my learned friend has submitted, then the whole purpose of 17A would be infructuous. So in that case, my lord, yes, obviously, in case of instantaneous arrest, there is no requirement of any kind of approval. But yes, then again, coming to any kind of investigation which regards to a say preparation of or the cases of and categories falling under my petition, my lord, 13B to be precise. In that case, my lord, 17A will be solely applicable, and without that, no other provision is there in the book. That is my humble submission, my lord. If the provision is very much clear, the statute book is also clear.
No, that is only in discharge of his official function, no?
Yeah, that's why, my lord, I am saying, suppose a superintendent of police, that he is the authority of, my lord, the appointment of the constable. He is the appointing authority. And there were, my lord, for appointing the say constables, my lord, the entire advertisement, government has sanctioned, my lord, 3 crore rupees. Out of 3 crores, my lord, he has conducted the entire examinations, my lord, within 1 crore. The 2 crore has been siphoned out. And moreover, they appointed the constables taking some bribe. Then it's come, my lord, 17A come, my lord, he is doing the corruption during his discharge of official duty. Suppose a superintendent of police, my lord, he, my lord, my lord, direction may be given to some businessman or the coal mafia that if you not paid monthly such and such amount, and I will lodge an FIR against you, and we will put you behind the bar. Then, my lord, that money which they have collected, using his official, my lord, power, using his positions, that is, my lord, not comes under his official functions. That is the distinction between the, my lord, the person who was a government servant. Here, my lord, the money which was sanctioned, that was siphoned, that's no, yes, 17A is required. He's using his official power, asking money from the businessmen and the other persons, my lord, taking some monthly basis money, that is just come under his official duty, my lord. No doubt he is a government servant. Then how 17A is applicable, my lord? Similar in 197, CRPC also says same thing, my lord. If the same is not doing in the official functions, my lord, is not, prosecution sanction is not necessary.
So, Mr. Sahu, can it be said that you have accumulated assets disproportionate to your known source of income, and that is in discharge of your official duty?
It is not my saying, my lord.
Then
it is saying of the FIR, my lord. The FIR is very much clear that during my service period, whatever it is, and whatever I did some kind of illegal activities, and as such, I have illegal disproportionate assets today. The allegations as such. So the FIR is, if the FIR is calling me under section 13B, then who am I to not say that yes, you are not connecting me to such and such allegations, my lord. The FIR itself is very okay, and for that reason only we are here to cause the thing. And the FIR is very much clear, then section 17A would obviously be applied, my lord. That is my humble submission.
No, FIR first part relates to the this arrest of the applicant while he was accepting bribe of rupees 6,000.
Yes. That is 7, my lord. Section 7 will cover that.
Yes.
But in this case, my lord, later on when they filed the FIR, and in the subsequent,
it was disclosed during search in your house.
Yes,
that 9,93,000 rupees were
6
recovered
lakh
from.
something, yes, my lord.
Yes.
6 lakh something, and some bank documents
Yes.
and a car RC. So whatever they have, their allegation is that I have accumulated such kind of assets during my service, and as such, 13B applies on me. And if 13B applies on me, my lord, then 17A would protect me. That is my humble submission, my lord. And the law is also very clear, and the Supreme Court is also very clear, at least on this point, my lord.
Which point? No, but provided the other ingredients of the section has to be satisfied with.
Then there is
You
no
must
case
accumulate it in discharge of your official duty.
If 13B is not attracted in this course of action, then obviously, lordship, there will be no case as such. But if they have applied 13B, implicating me under the PC Act, lordship, then obviously I have a protection of section 7.
No. Merely because the case has been registered under any provision of the PC Act, you will be protected under section 17. That is not the law.
That is not the law. I agree to that, but my lord, my contention is that any case which do not require instantaneous arrest, my lord. In a trap case, obviously there needs to be instantaneous, and there is no scope of application of prior approval from the concerned authority. That is a true and very established law, my lord. But in my case, my lord, prior approval as such is to be required because there is no scope of instantaneous arrest on this ground, my lord.
Mm.
The law is very much clear because the proviso itself is
No,
very
no,
much
that
clear.
is not, no, not the only requirement. The other requirement is that you must have to do it in discharge of your official duties or function.
Yes, that's what I'm saying, my lord. If the allegation says that I
So,
have,
no, my question is, can it be said that you have accumulated assets disproportionate to your known source of income?
Yes.
And it was your official duties?
the FIR is clear on that, my lord. I'm not saying this thing.
No.
FIR says such.
Okay.
Much obliged.
Heard Mr. Sahu, learned counsel for the petitioner, and also heard Mr. Phokon, learned PP for the state of Assam. Argument concluded, order reserved.
Much obliged.
Obliged also.
Item number 2, promotion.
May I please, your lordship? So it's a second bill application, lordship. Petitioner is behind the bar, lordship, already 117 days, lordship.
So what is the ground for filing this petition?
Lordship,
Second petition.
we have, so kindly go to the page number 5 and para 7, lordship. But because available records does not include that the proceeding under section 52A of the NBPS Act was undertaken by the investigation officer for preparing an inventory and samples drawn in presence of the jurisdictional magistrate, lordship. So as per
That's
the
all right,
government-
but this issue has to be considered at the stage of trial, not at this stage,
Lordship,
after
as per
taking
the-
evidence.
as per the Indian government notification, GR number so and so. and
Yes,
it-
that is there, but one judgment of Supreme Court, a constitutional bench judgment of Supreme Court is there. There it is stated that can be only considered after taking evidence.
Plus, at this kindly, case day may be called.
No, what purpose will be served? Because the trial is already going on. Some witnesses in the meantime might have been examined. You raised the issue before the learned court below.
Because in this case, charges has not been submitted yet, lordship.
In this case,
Lordship.
yes, Mr. Sharma, search is not submitted here.
Minor, that information is not available, minor.
Search is not submitted.
As per my information, lordship.
Where is the earlier order?
Earlier order, it was lordship. Annexure 4 lordship, page 20 lordship.
Oh, how many days you are behind the bar?
117 days, lordship.
117 days. Okay, Mr. Sharma, what is the case then? When?
Third minor, third appeal, minor.
Sorted?
28.
28. 28.
Item number 3.
Lordship for 39 application, my lord. The petitioner was arrested on 18/2, my lord. FIR may be seen at page 7,
He was arrested on 18/2.
18/2. FIR lost on 17/2, my lord. I'm not named in the FIR,
Hmm.
but police.
Where is the forwarding report?
Forwarding report, my lord? Page 15, my lord. Page 15. Police arrested me on suspicion, my lord. I am a ragman, my lord, the Kabariwala. When I was roaming at Satmile area, my lord, the police arrested me, but nothing has been recovered from my possession, my lord. And one another accused man who was on the day of occurrence was arrested, page 12. His forwarding report I have annexed.
No, your forwarding report is at page
Page
number
15.
15. Yes, Sharma?
My lord. CD, my lord, for that.
It's from Jalukbari.
Aminul Ali. Mr. Sharma, it is mentioned that the accused is named in the FIR. Where his name is there in the FIR?
Page 10 is vernacular, my lord.
My lord, one is Kalu, my lord. Second is Kalu. He
Hmm.
may be also then that person. my lord.
I'm not Kalu, I am Aminul. Alias Aminul. Forwarding report says Aminul. S15 can be seen.
No, no, কোনটা লাগে? কালু থেকেও পারে নামটা না। Nickname.
Heard Mr.
M. Ali.
Learned Counsel for the accused and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 439 services preferred for accused Aminur Islam alias Aminul Ali, who is languishing in jail Hazard in connection with Jalukbari PS case number 70 of 2024 under section 454 T8P 380 IPC. Since 18 to 2024, for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Manjur Ali. No, Maznur Ali
Majnur Ali.
on 17 to 2024. The sense of allegation made in the FIR dated so and so is that on 17 to 2024 in the morning at about 7 a.m. when Intaz Ali and Kalo entered into his house in order to commit theft, and then he, along with neighbors, apprehended one of them and recovered one ceiling. What is ceiling?
Ceiling fan, my lord. Ceiling fan.
And recovered one ceiling fan from his possession. The learned counsel for the applicant accused submits that the accused was arrested on 18 to 2024, and since then he has been languishing in jail Hazard, and that his name is not mentioned in the FIR and nothing has been recovered from his possession. And in fact, he is a
Ragman, madam.
He is a-
Kabariwala.
ragman. And at the relevant point of time, no, at the time of arrest, he was
He was roaming for
around the
purchasing, my
place
lord.
of occurrence or for his business purpose, and that he is ready to cooperate to the investigating agency, and therefore it is contended that the accused may be enlarged on bail. On the other hand, Mr. B. Sharma, learned additional PP, submits that at this stage, only the case area may be called for. Right. Having heard the submission of learned advocate for both sides, I am going to the petition in the documents, place on record, and also peruse the place on record. And it appears that the accused was arrested on 18 to 2024, and since then he has been languishing in jail Hazard. Further, it appears that his name find no mention in the FIR and nothing has been recovered from his possession. He is languishing in jail Hazard for last how many days?
26 days.
Last 26 days, and in the interest of investigation, his further custodial detention seems to be not warranted, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bundle of this 50,000 with one security of like amount to the satisfaction of the learned Chief Judicial Magistrate Kamrup M, the accused be enlarged on bail.
Highly obliged.
Item number 4. Matt, please allow.
my lord, it's a charge-sheeted case, my lord. And she's matter relating to POXO, my lord. So notice may go, my lord.
Heard Mr.
Receive for
Learned counsel for the accused and also heard Mr. B. Sharma, learned additional people for the state respondent. This application under section 439 CRPC is prepared by accused Mujibur Rahman, who has been languishing in jail as in connection with special POXO case number 24 of 2024 under section 376 IPC, 376 Roman 1 IPC, rendered section 4 of the POXO Act. Since the case has been registered under section 4 of the POXO Act, it is provided that notice be issued to the respondent number 2 by registered post with AD and also by usual process and also through the officer in charge jurisdictional PS returnable on when
3rd of April.
My lord,
Okay.
dusty may be permitted.
is there any provision in law? Is there any provision in the rule?
Criminal. My lord, that is, my lord, the practice of the court that, my lord, sometimes dusty is also permitted in criminal cases also.
Maybe, but unless it is provided in the act or in rule, we cannot. Some court may grant it, but
Yes. Yes.
returnable on Mrs. Sharma when
3rd April.
3rd of April. In the
Some
meantime,
early date, maybe, my lord, I pray because he's, my lord, more than 3 months, he's already in custody. My lord. And that is it's illegal retention, my lord, if I may say, my lord, I will submit to the effect, my lord, after LCI has been, my lord, received, my lord. After the resolution.
okay, that means that you have not been named in the search sheet.
I have named, my lord, but since, my lord, victim, my lord, she has been, my lord, her age has been determined on the basis of Aadhaar card, my lord. In fact, my lord, the Aadhaar card cannot be the basis to determine the age of a victim, my lord.
Who had determined?
My lord, that has been, my lord, taken into account in the search sheet by the investigating authority. That she is a minor. In fact, she is not a minor, my lord.
No, you can argue the matter at the time of framing of search.
My lord, since it's a illegal, my lord, in the investigation itself, my lord. So that's why, my lord,
No,
I may
that's all right.
permitted-
Even it is agreed that section 4 is not attracted. Why this section 376 IPC will not be attracted?
because, my lord, some consensual relation was there, my lord, as per the 164 statement itself. my lord.
We'll see later
No.
record come.
Yes.
17 years.
Returnable on 3rd of
3rd April.
3rd April, my lord.
3rd April. Okay. In the meantime, rest shall call for the scan copy of the record along with case diary from the learned court below.
My lord, that is Honorable Special Judge Poxo Hussain, my lord.
Item number 5.
And develop pleasure.
That's pleasure, Lordship. This is a 439 application and the affair is at vernacular is at your Lordships on page 16. And the type copy is at page 10, my lord. This is the
So
case,
POXO is there,
is there,
POXO,
man. 8 and
POXO 8 and 10 or
8 and
12 are
12.
there. Notice will go at this
Fine.
cases.
Lordships, here we are behind the bar since 25(1) and the provisions of section 8 and 12. 8 is for 5 years maximum and 12 is for 3 years, Lordships.
Then,
And we are behind the bar since 25(1).
but the law is that without hearing the other side,
Other
we
side.
cannot.
Okay, Lordship,
Consider
that
your-
may be considered covering the days of 60 days, Lordships.
Same order, notice be so returnable on when, Mr. Sharma,
My lord, Kamrup Metro itself.
Kamrup Metro.
27, my lord.
27.
My lord.
27. Lordships,
Yeah, investigation is going on.
investigation is going.
Oh, that, okay. From which PS?
It
This
is
will come.
Satgaon.
Satgaon, Satgaon.
Maybe on,
Sorted.
maybe on 22, Lordships, because after 24th, I will not be available, Lordships, for 10 days.
That's all right, but would you be
Notice
able
they
to
will
call
have-
service of notice?
This, my lord.
22, it will go, Lordship. There, the address of the informant is also here in local.
No, that's all right, but okay, 22. then.
22. Lordship.
Then under the schedule, I'll put it.
No, you have to produce the CD along with the statement of the
Right.
victim girl recorded under section 164 CFS. Next item.
Item
Lord.
number 6.
This lordship. Lordship, this is POCSO case, lordship. The accused was arrested under section 12 of POCSO Act and the section 354 of Indian Penal Code. The lordship, I am behind.
Yes.
Last occasion, lordship, police. My lord, I have received the, my lord, on WhatsApp, my lord. Printout copy is yet to come, my lord, from our office, my lord. After some time.
What is the instruction?
That is, after some time, after some time. I will place the written, my lord.
Okay.
After some time.
Item number 8.
May I pray before worship, seeking adjournment for 1 week because leading advocate Jay Barbara is for some personal difficulties.
What is your name?
Mr. SZB Atlas.
Pardon?
Mr. SZB Atlas.
Mr. So-and-so, learned counsel appearing on behalf of Mr. J.I. Borhuya. Learned counsel for the petitioner submits that Mr. Borhuya is out of station and therefore prays for listing the matter after 1 week. Bear allowed.
My place, your lordship. Lordship 439, behind the bar, lordship 70. Any lordship, see.
Record has been received.
Lordship.
Mr. Borua, have you gone to the record?
My lord, I have gone to the record, lordship. My lord, case is still fixed for the appearance of the co-accused, lord. Otherwise, my lord, 164 statement, there is some allegation, my lord, although there is no direct allegation against the Iman Ali, lordship. But lordship, there is allegation that one man, lordship, that name has not been disclosed, lordship. Omitted there.
Sir, lordship, Afazuddin is abscondal lordship. Someone also issued lordship, but he is abscondal lordship. As per 161 statement lordship, she was not mentioned my name lordship. She was mentioned only Afazuddin and Zakir Hussain lordship.
But you have been solicited.
Yes, lordship, but I am not involved in this case, lordship. Actually,
Cognizance also
actually,
taken.
as per Azahar, not my mention, I am not the name mentioned Azahar. Our statement
But
also.
since you have been solicited, there are some materials against you.
Lordship, after second, third year, lordship.
Hmm?
Otherwise, lordship, she recovered from my possession, lordship. That's why, lordship. In that time, police
Victim
not-
was recovered from your position.
Yes, lordship.
Then can
Because,
it be said
lordship,
that
because both are victim or accused, both are family relation, lordship.
hmm,
She voluntarily came out, lordship. In my room, house, lordship. After that,
whether the notice was served?
yes, lordship, notice was served.
When and how?
Lordship, date of receiving 04/03/2024.
Where you have got it? No, this is acknowledgement. This is acknowledgement of submitting
yes,
the
submitting the-
steps
yes, yes.
in the section.
Yes, lordship.
So it will not do. No? You have taken a step by registered post.
Yes, lordship.
When?
Lordship, I think 9-10 days, lordship.
Then you obtain the consignment number from the section and thereafter track it in the website of the postal department.
Yes, for lordship office note, I think it may be received by
Office note.
office note. AD card not returned, lordship.
No, there is no office note in respect of service of notice.
Lordship may consider behind the parcel.
No. The opportunity has to be afforded to the other side.
Lordship.
You track the consignment.
Copy is received, I think, lordship, AD card not received.
Which copy? The scan copy of the record has been received from
As
the
per-
learned court.
Lordship, as per office note, lordship, I think.
Yes. As per office note, scan copy of the record has been received from the court below. Up to date status report. What to do? You want to take fresh step or you will await service report?
The lordship may short date, lordship.
Short date. Office note dated 13/3/2024 indicates that AD card in respect of service of notice in respect of respondent number 2 has not yet been received. So rescission leaves the matter after 1 week awaiting service report upon respondent number 2. In the meantime, the learned counsel for the accused shall obtain the postal consignment number from the registry and thereafter track the same in the website of the postal department and thereafter produce the report before this court on next date.
Lordship may date, fix a date, lordship.
Yes.
27 March.
20, lordship, 22, lordship.
22.
22. Obliged, lordship.
Item number 10.
May pleasure lordships. Lordship 439 application with regard to offence under alleged offence under NDPS Act, my lord. There are 3 accused persons in the instant matter, my lord, of alleged commercial quantity. Last week, lordship, 2 of the petitioners had approached this honorable court and lordship had order dated 7/3/24. And after going through the LCR at length, has granted lordship bail to the other co-accused. Lordship, I was also not apprehended in the same manner along with the vehicle, my lord, or with the alleged contraband substance. They were not from my possession. And my lord, on earlier occasion, learned prosecution had fairly submitted, my lord, that the material against me is that the co-accused persons, these 2 gentlemen, my lord, Neel Kamal Biswas and Rahul Biswas, they
When-
have made statement against me, my lord.
When submitted?
My lord, on the earlier occasion, my lord, LCR had come on earlier occasion in my matter also. Then going through the LCR, my lord, it was submitted by the prosecution that the material against me is that the statement I have been implicated by the other co-accused persons. And LCR would reflect, my lord, till date the witnesses who have been examined, not a whisper against me, my lord. I was not apprehended along with the goods, my lord.
Okay, we'll see.
My lord, as part of my last order, lordship, 2 prosecutor witnesses have been examined, lordship, and they are both Caesar witnesses, lordship. Last PW2 was examined on 3/1/2024, lordship. After that, there is no report whether further witnesses examined or not. So let the my lord, up to the status report be called
My
for.
lord, last week,
Taking a
lordship had
full-
Peruz, my lord.
No, that is
Another
the update
witness,
up
my
to
lord,
the T1, lordship.
another witness has been examined, my lord, Caesar witness, my lord.
More than
You can
2.5
find some copy,
months.
my lord. 1 PW3 has been examined, my lord. I have the copy, my lord.
Okay, in the meantime, let the up to date status report come.
Yes.
We'll see whether record was called for here.
Record is called for, my lord. Yes,
Yes,
record is come, my lord.
record has come.
Record received.
Yes,
Record received, my lord. And up to date also called subsequently in my matter,
But
my
up to
lord.
date has not come, lordship. Only last witness examined on 3/1/2024, lordship.
My lord, co-accused is on this basis of same record, my lord, last week. And because the listed up before in another bench, my lord, because lordship had gone through this matter, it's been fixed today before lordship, Rajan. My order dated 12/3/24, my lord.
So when the up-to-date status report was called for?
Was year 2023, my lord, date fixed.
Hmm? When?
My lord, in December last year, my lord. My lord, give me just one moment, my lord. That would. 18/10/23, my lord, then 29/9/23 also, my lord. If I may draw lordship's attention to the order dated, my lord, 7/3/24, my lord.
No, there's a up-to-date status report was called for and received on 3/1/2024.
Yes, my lord. So, it was for.
Now, after that, there is no report, Lordship. 3/1/2024. So that is why I'm praying that, my lord, let the up-to-date status report be called for, Lordship. Even witnesses, because there are three.
Yes,
accused
my lord, I am
persons.
submitting, my lord. One witness has been examined. This is the copy, my lord. Give it to him as well, my lord. One Caesar witness has been examined, my lord, subsequent to that, my lord.
Let it come officially. Sort that.
My lord, if you wish seek instructions, my lord, you can.
No, we cannot see instruction, Lordship. This is a matter of search that.
Solicited as a from court, he cannot. Mr. Arjay Barua learned additional PP submits that up-to-date status report is not available before the court, and therefore he prays that up-to-date status report may be called for from the learned court below. Here is accordingly allowed. The shall call for the up-to-date status report from the learned court below, fixing the matter on 20 or 21.
22, Lordship.
20?
22. 21. 21 then.
20.
21. Item number 13. Hello, item number 13, Lordship, we have received the case diary, Lordship, on the last occasion. But Lordship, it is pending for the FSL, Lordship. That's the case of 302 IPC, Lordship. And today morning we have inquired, Lordship, FSL report is not ready, Lordship. I'm already.
Not ready.
Not ready. We have verified from the police station, Lordship, today morning.
I'm behind because you know for 46 days, you know.
Although there is no direct allegation against him, Lordship, I'm fairly submitting notice, but my lord, since the mother case of 302, Lordship.
Eyewitnesses are there, you know.
Pardon?
Eyewitnesses are there, you know.
No, but the thing is that how the date of the victim took place, that has to be ascertained first.
Yeah.
Mr. Arjay Barua learned additional PP submits that he has not received the FSL report.
On next Friday, you know.
Where is accordingly allowed, recessal is the matter on
Friday, you know.
Friday, then next Friday.
next Friday.
Next Friday. 22nd March.
Apply to them.
Item number 14.
May I please? One of the petitioner is a lady lordship, everyone minor side. And he is behind the bar for 36 days lordship, as of today. My lord, FIR is a case lordship. 10 lordship.
Yes, CD was called for here.
Yes, the case that is received, Lordship.
But,
So is there any material against the accused?
Materials is there, Lordship. What happened, Lordship, when 16-year-old girl, Lordship, she got pregnant, Lordship. Then, Lordship, my lord, aunt, her name is Tasnima Khatun, Lordship. She brought her to the hospital and she delivered a baby, Lordship. Now, my lord, the baby was delivered by the other two nurses, Lordship, in the hospital. Now, this lady, Lordship, the accused petitioner, she is also GNM nurse, Lordship. Now see what she has done, Lordship. She along with this Taslima Khatun, Lordship. That is the statement of the Taslima Khatun. They sold the baby to one couple, Lordship, who was childless, Lordship. That is the allegation against her, Lordship. Although this she has denied. And now, Lordship, the little baby has been recovered, Lordship. But this is the allegation against her, Lordship.
So baby has already been recovered.
Baby recovered, Lordship. But
So
allegation
whether further custodial detention is necessary?
My lord, as per the case diary, Lordship, investigation has progressed sufficiently, Lordship, because the seizure has been made, Lordship. Hospital register has been, my lord, seized. And my lord, other two nurses also arrested, Lordship, including the, my lord, aunt of the accused person, Lordship.
Mm.
That is, the investigation is progressed, Lordship, sufficient. But it is, but Lordship, it is pending, Lordship.
But
Investigation is pending, Lordship, but sufficiently progressed.
yes, Mr.
I have respondent number 2, my lord.
Mm.
They filed affidavit, my lord. As per affidavit, I have no knowledge about her involvement. My lord. I have filed affidavit, my lord, and affidavit, my lord, as per my knowledge, my lord, I have no knowledge regarding involvement of
That lady.
lady, my lord.
Acha.
But another two nurse, my lord, Akruma Khatun and Minu Montaj, my lord, as per my
No,
knowledge,
they are not before us today.
my lord.
For how long you were behind the bar?
36 days.
30?
36 days.
Heard Mr. M. Khan, learned counsel for the accused, and also heard Mr. R.J. Barwa, learned additional PK for the state respondent, and Mr. Padgiri, K.R. Padgiri, learned counsel for the respondent number 2. This application under section 439 service is prepared by applicant Srimati Sumjan Khatun alias Munni, who has been languishing in jail in connection with Mankasar PS case number 24 of 2024 under section 376(2) and 376(3) stroke 317 IPC reduced section 6 of the POCSO Act. The sense of allegation made in, no, it is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Mizanur Rahman Sheikh on 24 January 2024. The essence of allegation made in the FIR dated so and so is that one victim girl, namely Srimati X, aged 16 years, had given birth of a female child at District Civil Hospital, Hatsingimari. As a consequence of her illicit love affairs. She has stated that one, Rebecca Sultana, no. She has stated that her maternal aunt has brought her to the district civil hospital, Hatsingimari, for her delivery. And after the delivery, the victim heard the cry of the newborn baby and want to see the baby. But Rebecca Sultana, with the conspiracy of with the delivery nurse and without showing her baby to her, handed over the baby to someone as adoptive parent. Mr. Khan, learned counsel for the applicant submits that, accused submits that the present accused. Who was she?
My lord, she was nurse.
That the present applicant, present accused has been working as nurse in where? Was working as a nurse in?
civil hospital, district civil hospital.
District Civil Hospital, Hatsingimari, and the victim baby, and the baby has already been recovered and handed over to her mother. And the present accused is no way involved with the offense alleged. And therefore, Mr. Khan submits that she may be allowed to go on bail. On the other hand, Mr. RJ Barua, learned additional PP, also submits that produced the case before this court and submits that the victim baby has already been recovered and handed over to the mother of the mother, and that the present accused has not been implicated by the informant, and the investigation is sufficiently progress here, in this case. On the other hand, Mr. Patgiri, learned counsel for the respondent number 2, submits that the respondent number 2 has filed an affidavit stating that she has no knowledge about involvement of the present accused with the offense alleged in the FIR. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents, plus on record, and also perused the case diary with the assistance of Mr. Barua, learned additional PP. Indisputably, the baby has already been recovered and handed over to her mother. The case diary indicates that the IO has achieved substantial progress in the investigation of this case, and material part of the investigation almost appears to be over. And in that view of the matter, custodial interrogation of the applicant seems to be, custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the learned Special Judge Pakso Hatsingimari, South Salmara, the accused be not Hatsingimari, South Salmara, the accused be enlarged on bail. CDB return.
Item number 15.
None appears for the accused and come.
May it please your lordship. May it please your lordship. May it please your lordship.
Hey, how do you do?
May it please your lordship.
Yes.
Lordship will find the FIR from page 11, your lordship. From page 11. Your lordship, the petitioner is implicated under section 380 and 411. There are other accused also. On a bare perusal of the FIR, your lordship will find that 380 doesn't attract. So 411 is meant for the petitioner. That is, he has received a stolen property. But here to your lordship, the knowledge and the element of dishonesty is required. I have categorically stated, your lordship, he is a licensed, your lordship, he has got trade license. He used to receive these particles from rag pickers, and he has no knowledge whether this property is stolen or not, your lordship. The maximum punishment, your lordship, under 411 is 3 years. He is behind a bar of around 35 days now, your lordship.
So, Barua, you received the case diary.
Yes, case diary received also.
Is there any material
My lord,
against
the
the?
stolen article recovered from his house, lordship. And my lord, he said, I purchased the stolen article lordship, from the accused person.
But whether he had knowledge that those articles were stolen article?
My lord, it is not specifically stated, lordship, but he said, I purchased the, my lord, goods.
Your lordship, quite honestly, your lordship, I have annexed the licenses. I have the certificate of registration,
Not
registration,
necessary.
your lordship. I have bought those.
Not necessary.
He said that I have not heard that it was stolen articles, lordship. Those articles.
But definitely he will say that.
Definitely not, sir. Otherwise, my lord, if somebody comes to me, I'll never purchase any bush without any document.
So stolen articles have been recovered. Okay, heard, Mr.
35 days.
What is your name?
I Hussein, Your Lordship.
Learned counsel for the accused and also heard Mr. Arjay Bodo, learned additional speaker for the state respondent. This application under section 439 CRPC is prepared by accused Rahmat Ali alias Raham Ali, who has been languishing in jail as in connection with Bongaigaon PS case number 51 of 2024 under section 380 411 IPC. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by ASI Sandakanto Borough of North Bongaigaon Police Patrol Post on 10/2/2024. The essence of allegation made in the FIR dated so and so is that accused Lobokumar Borough, Raham Ali, and two others accused, namely Lalu Prasad Borough and Dhansorang Borough of Sapaguri, have stolen some articles like water pump set, rod cutter motor, etc. from the various places and sold the same to Rahmat Ali. And on being laid and shown by accused Lobokumar Borough, the aforementioned articles were recovered from the possession of Raham Ali and seized the same preparing seizure list. The learned counsel for the accused submits that the accused was arrested on
Your Lordship, he
on
was
10
forwarded.
2024 and for last 35 days he has been languishing in jail of it. The learned counsel for the accused further submits that the stolen articles have already been recovered from the house of the accused and at best section 411 IPC will be attracted against him, and that the petitioner has had no knowledge that the articles he have purchased from the rug pickers are stolen article, and that the accused is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. On the other hand, Mr. Arjay Bodo, learned additional PT, has parted the case before this court and submits that the stolen articles have already been recovered and the investigation has progressed sufficiently. Thereafter, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on the record and also urged the case diary with the assistance of Mr. Bodo, learned additional PP. It appears that the stolen articles have already been recovered and seized from the possession of the accused. The co-accused have also been arrested. Investigation also appears to be progressed sufficiently, and as such, further custodial detention of the accused, in the interest of investigation, seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 zerotive like amount to the satisfaction of the learned chief judicial magistrate, bowing out the accused being represented.
Item number 16.
Oblige, Your Lordship. Oblige, Your Lordship.
CD was called for. Case diary received, Lordship.
So is there any material against?
Material, they have demanded some money, Lordship, and they said, Lordship, we to develop the road and to build one mosque, Lordship. So the money was asked, Lordship. Although there are allegations there, but they have demanded, and if the amount is not paid, then the mother came to kill. It was the allegation against the mother person. 33 days, Lordship, as of today.
the petitioner is the secretary of the Muslim committee lordship and the collected some money lordship. And they are not collected the money, they have contributed the money lordship. They contributed the money to build the construction of the mosques lordship. And this is the resolution lordship, the villagers lordship.
So what is the stage of investigation, Borwa?
Investigation lordship, the other accused person lordship, police was searching, my lord, he, my lord, obtained interim protection from this honorable court lordship when he appeared.
And for the lordship item number 17 lordship, I'm on interim lordship appeared and recorded my statement on 1st March 2020.
That is the last update lordship, the other accused person, he appeared and his statement recorded.
Yeah, heard Mr. MZ sir, learned counsel for the accused. You were behind the bar for how many days?
32 days lordship.
30 days.
33 days.
33 days. And also heard Mr. Ajay Borwa, learned additional PP for the state respondent. Therefore, there's page number 18, para number 2 and 3. Mr. MZ Shah, learned counsel for the accused, submits that the accused was arrested on 12/2/2022, and since then he has been languishing in jail hazard. Mr. Shah further submits that though the name of the accused find mention in the FIR, yet he, along with other co-blazers, have collected money for only for doing the development works of the village, and that he is ready to cooperate with the investigating agency, and therefore Mr. Shah contended to allow the petition. On the other end, Mr. Ajay Borwa, learned additional PP, submits that the investigation of the case has progressed sufficiently. However, the IO has collected some materials in support of the allegation made in the FIR. Better, having had the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Borwa, learned additional PP. In view of the materials collected so far in the case diary as well as progress of investigation, and also in view of the period of detention, then balancing the same with the nature and gravity of the offense, this court is of the view that further custodial detention of the accused may not be warranted in the interest of investigation, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 surety of like amount to the satisfaction of the learned chief judicial magistrate Kamrup M, the accused be enlarged on pay. CDB returned.
Other case, he was granted interim lordship height order dated 26/2/2024. Pursuant to that, mother, he appeared, statement recorded.
This page number 2. Order dated 26/2/2024. You start from page paragraph number 4. Mr. Chaudhary, learned counsel for the applicant, submits that this court right order dated 26/2/2024 was placed to grant the privilege of periodic bail, and pursuant to the said order, the applicant had appeared before the IO and cooperating with the investigating agency. And therefore, Mr. Chaudhary contended to make the interim order dated 26/2/2024 absolute in the same terms and condition. Whereas Mr. Ajay Borwa, learned additional PP, has produced the case diary before this court and confirmed the appearance of the applicant before the IO. And further, Mr. Borwa submits that the IO has achieved substantial progress in the investigation of this case. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Borwa, learned additional PP. But in view of the materials collected so far in the case diary as well as the progress of investigation, And also in view of the cooperation being extended by the applicant to the investigating agency, his custodial interrogation seems to be not warranted here in this case, and therefore the interim order dated 26/2/2024 is hereby made absolute in the same terms and conditions.
Highly obliged.
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 Item number 18. Item number 18, my lord, may be taken up at 2 PM also.
Why?
My lord, sir, we have received the case there is just now.
Acha. Okay.
At 2.
Item number 19.
Petitioner behind bar for last 21 days, my lord. Category was called for.
Received. So what is the stage of
Uh,
investigation?
Allegation is my lord C79 and section 66C and 66D of IPA.
What is the allegation?
Yes, my lord. My name is not in FIR, my lord.
No, I am asking you, what is the allegation against you?
My lord, in forwarding report, my lord, kindly see, my lord. Page 13, my lord. I am Noor Ahmed Barbhoya.
Yes, Mr. Locker.
Lordship, in the statement, the present petitioner statement is recorded, Lordship. He has stated, Lordship, that he and his brother mainly involved in this crime, Lordship. And so many times they have withdrawn money from others, from the others' bank account, Lordship.
No, except that statement, his own statement and co-accused statement, is there any other witnesses?
Lordship, some other persons,
Co-accused already granted bail this honorable.
other witnesses are also there.
I am not
Lordship, who
asking.
has- Some other witnesses are also there, Lordship, who has stated, Lordship, that this person, his brother actually, and this person's brother came to them to get a SIM card, Lordship, like that, Lordship. How they have changed the SIM card of others, Lordship. That is there, Lordship.
SIM card of mobile phone.
Mobile phone, Lordship. They used to get some free SIM card in the name of some other person. Thereafter, they get the message, money transferring message in their mobile number, SIM number. Thereafter, they make the transfer. They transfer it to their own account, also, like this, Lordship.
So, no, is there any evidence that they have transferred money from the account of the informant to their own account or to accounts of some other persons?
There, Lordship. Bank statements are also there, Lordship. It's here, Lordship.
No, statement received, that's all right, but is there any material to support?
That is, it is supporting, Lordship, that they have transferred it on their money, Lordship.
Where?
Some other
In
person,
whose
Lordship.
account?
Some other person, and who has also stated, Lordship, that that money has been transferred to his account, Lordship. 10,000 like this way, Lordship.
No, his account.
Lordship. Not his
Accu-
account, Lordship. He used to transfer it to some other person's account, Lordship. Thereafter, he collected money again. He directly not
Whether to that effect, bank statements are there.
Lordship. Bank statements are there, Lordship. Bank statements are there, Lordship.
There. And what is the stage of investigation?
Stage, Lordship, the main petitioner, he is the main person, Lordship. And his brother is also the main accused person, Lordship. They are arrested, Lordship. And some other persons are involved as per their own section, Lordship. Some other persons are involved in this entire racket, Lordship. They have not been arrested. They have not arrested, Lordship.
Mm.
If at this stage they are released on bail, Lordship, there was other accused person may not be arrested, Lordship. Or
But some of them are already
Yes,
granted
my
bail.
lord. Page 16, my lord.
Mhm.
Co-accused already granted bail.
That is all right, but are you in the same footing of that accused who has been granted bail?
Page 16. Bilal Ahmed. Bilal Ahmed and Abdul Hai Major Bhaiya, my lord. They are main accused. And Minazuddin, my lord. He is already arrested, my lord. Minazuddin, my lord.
So bank statements have supported the version of the accused that he has transferred money.
So I haven't gone through the entire bank statement. So many bank statements
No,
are here. I haven't gone through entire bank statement, Lordship. But Lordship, the person who has already been arrested, Lordship, he himself is stated, Lordship, through bank
No,
transfer.
that's all
he
right.
got-
If the bank statements are available, you go through the bank statements. Whether the bank statements supporting his version or not. You assist the court after some time. Let him go through the bank statement.
Item number 20.
Marriage. The matter related to my lord, elopement, my lord. The petitioner, my lord, the victim is my lord 17 years, my lord, 5 years old, my lord, and there are law affairs. And victim has already been recovered, my lord. 162 statement has been recorded. And now,
Whether notice was served upon the victim, upon the informing.
no, sir. We have taken a step, sir.
Yeah, in this case, Lordship, CS submitted, Lordship.
CS,
Yes, submitted.
when?
Lordship, 13/3/23/24 on 30.
30?
On 13/3/24.
13/3.
By CS number 14/24,
Dated?
13/3/24. Under section 366 IPC and added section 376(1), 419, 379 IPC. Read with section 6 of POCSO against Mohammed Akbar Ali. Akbar Ali.
So go and approach the trial court.
That's your.
Or we can call for the case diary, no, case record.
Case report. Our sessions are set, can't wait. We have to wait till my lord recording the statement.
Then in this case, Lordship, as POCSO is added, Lordship, notice will also go. Lordship.
No, notice on this.
No, but there is no service report.
Then it has to be serviced.
So office not dated.
LCM in the meantime, notice me, sir.
Okay, office not dated 13/3/2024 indicates that step has been taken upon respondent number 2, but service report has not been received. Okay, Mr. P.S. Locker learned additional PP submits that he has not received the case, but as per his instruction, the IO has completed investigation and submitted search sheet, being search sheet number
Lordship. Okay. Search sheet number 14/14/24.
14 of 2024, dated 13/3/2024, under section 366, 376(1), 419, 379 IPC. In view of above, it is
Really?
provided that a registrar shall call for the scanned copy of the record along with the case diary from the learned court below.
When the learned sessions are POCSO.
That is learned sessions as FOXO. So no, learned special judge FOXO,
POCSO.
not looking for. Fixing the matter on when?
1st of April.
1st of April. The learned counsel for the petitioner shall also take fresh step upon respondent number 2 by registered post and also by usual process and also through the officer insert jurisdictional PS. From Dakwakana PS,
Item number 21.
CD of business. CD we have not received.
not received. From which PS?
Forum to Lordship.
From Mr. PS Locker learned additional PP submits that he has not received the case diary and press for granting him some more time. PR allowed. List the matter on when?
On 27.
27. পাঠাই।
Item number 22.
It is a rejected one case lordship. Other rejected lordships. I oppose this. Today lot 82 days lord.
Pardon?
Today 82 days.
But we have not, here also we have not received CD.
Lordship, but considering that like already lordship has gone to the CD and already documented evidence, only we have whatever we have not, we are not to influence anything, any witnesses lordship. We cannot influence anybody lordship. That grounds lordship, and considering the end of the 82 days behind the word.
You see, this section 409 is there.
8 days is remaining lordship. Then also lordship, only the 8 days lordship,
No, that's all right, but we have rejected earlier after perusing the case.
lordship, last day lordship has.
So on Monday, you produced the case diary. Mr. Locker Lordet additional 50 submits that he has not received the case diary. Had it been not the second time,
Lordship,
we would have granted you the bail.
Second time already there. Second time already.
Accordingly, it is provided that Mr. Bortapio Mr. Locker shall produce the case diary before this court on Monday.
obliged lordship.
Item number 23.
439 application lordship. Petitioner is in jail for 24 days. The FIR is in page number 17 lordship.
Forest.
Locker, are you appearing here?
If it is forest matter, then I will not appear. Forest.
We have informed them in the morning itself.
Oh,
Forest department, we have informed them.
They will appear, I will call them.
After some time?
Item number 44.
May please lordship. My lord, allegation under 21C of the NDPS Act lordship. This is second application lordship. LCR has called for it.
LCA not received.
Lordship, the LCR has called for the second time lordship. Earlier, it was called by order dated 5/2 and next 22 lordship. Lordship may for a moment kindly see page 30, a small paragraph, 2 lines paragraph, lordship may kindly see page 30. Last paragraph, it is further provided that the learned trial court shall make an endeavor to complete recording of evidence of prosecution side within 3 months from the date of receipt of the certificate copy of this order, lordship. Lordship, 4 months passed already, lordship. Probably the statement of the.
Let the scan copy of the record come, we will see. How many witnesses are examined till date?
Only 4 witnesses examined till date, lordship, and last witness was examined on 6/10, lordship. Thereafter, no witness examined. Lordship, already 341 days I am in custody. Only 18 bottles of escape cough syrup was recovered.
But in the event of your conviction, how many days you have to remain in jail, Azad?
That's true, lordship, but the honorable court's order is not followed, lordship, page 30. Within 3 months, it was directed to complete the recording of the evidences, lordship, but that is not done. And 341 days I am in custody.
See, why the court below could not do it?
Whether that copy is furnished to the.
Yes.
Did they say comes?
Office note dated 1/3/2024 indicates that scanned copy of the record has not been received from the learned court below. No, 14/3, not 1/3. Registry shall issue reminder to the learned court below for transmitting the record without further delay. Place the matter on
Second of
sorted.
20.
27. Obliged, Lordship. Item number 24. Please, Lordship.
Well, in this case, my lord, the election against the petitioner and his father lordship, as regards my lord, child marriage lordship. My lordship granted my lord, interim bail lordship. My lord, then my lord, charge sheet was submitted lordship.
Charge submitted.
Yes, lordship. My lord,
Yes, law court. What is the charge sheet number?
number,
We have not
my lord, my father, my lord, has received someone from the special judge lordship. See, now, charge sheet number is not there, special case number is there. lordship.
but Lordship, whether it is in connection with this case or not.
This is instruction lordship.
Okay,
As per the instruction, Lordship. I have to
My
do-
lord, as per
Uh,
instruction, my lord,
Okay, we will take it up at after 1 hour,
at two
12:30. In
At
the
two-
meantime, he will obtain instruction.
lordship.
The charge sheet number,
At two lordship.
not 2. 12:30.
Obliged.
Item number 25. Please, Lordship.
Yes.
CD not received, Lordship. CD we have not received.
Mr. P.S. Locker learned additional PP submits that he has not received the case. Accordingly, it is provided that Mr. Mr. Locker shall produce the case before this court on when?
Lordship from Golokans, Lordship on interim as an interim. Then Lordship 4, Lordship 4.
Oh,
Lordship, interim is there. May I continue?
yes, till next that interim order dated 10/11/2023 shall continue.
Okay. Item number 26.
May it please your lordship. The FIR, that's at page 11.
Yeah, in this case, Lordship, charge sheet submitted, Lordship.
What is the number?
CS number 203/23, Lordship. 203/23, dated 31/12/23. Under section 448/376 to 1/511/354B. Read with section 8 of POCSO Act.
Heard Mr. Devre, learned counsel for the applicant, and also heard Mr. Locker, learned additional PP for the statement on that. This application under section 438 CRPC is prepared by applicant Mizarul Islam, who has been apprehending arrest in connection with Dean PS case number 154 of 2023 under section 448 T76(2), written bracket 1, Roman 1, stroke 511, stroke 354B IPC, read with section 8 of the POCSO Act. It is to be noted here that above noted case has been registered on the basis of an FIR lost by Sohidul Islam on 23rd/8/2023. The sense of allegation made in the affair dated so and so is that on 18/8/2023. The accused taking the sons of his and other family members' absence in his house attempted to commit rape upon his daughter. Rape upon his sister, namely Timothy X, aged 12 years, under threat, and also outraged her modesty. So, Mr. Devi, you have not been granted the.
No.
prayers. Mr. Devi, learned counsel for the applicant submits that. What is your submission?
I will be at least protected, your lordship.
Pardon?
I will be protected, your lordship. I'm ready to face the trial, your lordship. The allegations against me are not true, your lordship. Although I've been charged with this without investigation.
That allegation against the present applicant is false.
Yes, your lordship.
False and that he has not committed such offense and that he is ready to face trial and therefore it is contended to allow the petition. On the other hand, Mr. E.S. Law Court learned additional PP submits that
He has been shown absconder.
that the IU has already completed investigation and submitted search sheet. Being search sheet number 203 of 2023 dated 31/12/2023 under section 448 376(2) within bracket 1 stroke 511 stroke 354B IPC dated section 8 of the POCSO Act. And as such, Mr. Law Court has opposed the petition, but having heard the submission of learned advocates of both sides, this court is inclined to dispose of this application by directing the applicant to appear before the learned court below on or before
4th of April.
and to apply for regular bail. And the event of filing such an application, the learned court below shall consider the same in accordance with law. But considering the submission of learned advocates of both sides and also considering the facts and circumstances on the record, this court is inclined to extend interim protection to the applicant till his appearance before the
He-
learned.
I'm not on interim, your lordship.
He has been shown
I have
absconder.
not on interim, your lordship.
It means that you are not required any protection.
No, I'm sorry.
But lordship, he has been shown as absconder lordship
Yes,
in the search sheet.
I'm sorry, your lordship.
he will appear and apply for regular bail
Yes.
in the court below.
Yes.
So till then, till his appearance before the court below, we are granting interim protection to him. And in the event of his arrest, that 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, two conditions, last condition, no, the first condition, he shall appear before the IO, before the learned court below, on or before that date. And that is the second, he shall not try to influence any witnesses.
I'm deeply afraid.
Item number 27. May please, your lordship. My lord, the affair is based. Here was a circle officer of this full revenue circle. Lost the affair. My lord. Here when the present petitioner is not named in the affair. Here, my lord, the allegation in the affair is that
Yes, you received the case diary, Mr.
Receipt lordship. But it would not go to lordship. Foreigner city lordship. It takes and then lordship, can it be fixed on Monday lordship? With go to lordship.
my lord, in fact, his name is not there, my lord, because on co-accused, my lord, he is by professional advocate.
Other lordship,
He was arrested in this case.
Earlier,
What happened? The present petitioner engaged that counsel in some cases.
Let him
Now-
go to the case diary.
He is not,
earlier, lordship, earlier, there was a direction to update the city lordship, but it is not updated lordship. because Lordship, last entry is 16/12 Lordship. Therefore, it is not updated Lordship.
When?
Last entry is 16/12 Lordship. 16/12,
Okay, all right, till then,
sorry, 14/12.
Then, my lord, so many occasions, my lord, case was fixed.
that's all right. Now CD is available before the court. Mr. P.S. Locker learned additional PP submits that he has received the case ID, but he could not go through the same. As because the CD is voluminous and therefore prays for listing the matter on Monday. Fair allowed.
Item number 28, date. Monday.
Favorable lordship. My lord, can you see FIR page 9? And a notice was sent to the respondent number 2 and she has also received the notice. Only she flagged M left side. I have seen the record.
Here also she has submitted Lordship, but Lordship section we would not collect Lordship.
My lord, I am an old man of 72 years. And there is a land dispute regarding first land of half bigger. They want to occupy my land which is under my occupation since long. So that is the real.
Okay, let him obtain instruction in respect of the number of search sheet.
CS number we have received, but Lordship the section we could not receive.
Yes. At 2 p.m. today.
Lordship CD is not available. CD may be called for.
How do you come to know that the CD is not available?
There is a list that we used to affix. There is a list we used to affix.
Acha, acha. Mr. P.S. Locker learned additional PP submits that he has not received the case ID. Accordingly, it is provided that Mr. Locker shall produce the case ID before this court on
Service
27 March.
Service completed or not?
No.
Photo is there, Lordship.
Office note dated 13/3/2024 indicates that unserved notice has been received by the registry in respect of respondent number 2. The process server of Office of the Chief Judicial Magistrate Kamrup M reported that the respondent number 2 is not found in the address furnished in the notice. In view of above, it is provided that learned counsel for the applicant shall obtain the correct address of the respondent number 2 and thereafter take fresh receive upon him by registered post and also by usual process. Returnable on
5th of April.
5th of April.
Item number 31.
30 or 31? 30.
Here also Lordship CS submitted Lordship.
So we have appeared before the IR lordship.
What is the search sheet number?
14/24.
40
dated 25/2/24.
under section.
That is not there. That is not.
So I will collect it.
I will.
When?
F2 Lordship. Or he was on interim lordship, earlier he had it.
No, that's all right, but we'll dispose of the matter. You obtain the sections and the number. Okay. 31.
Yeah, please, your lordship. On the last day, on the last occasion, my lord, CD was called for. Matter.
CD not disclosed.
Mr. Locker learned additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Locker shall produce the case diary on
His full lordship. On 2nd of April lordship.
2nd of April. Till then, interim order dated 16 to 2024 stands extended.
Item number 33.
CD received, my lord. 33.
None appears for the applicant on call. Resist shall raise the matter after 1 week.
CDB retained.
Till then, CDB retained.
Item number 34. By order dated 22/2024, CD was called for.
Yes, Sharma?
CD not received, my lord. They are interim, my lord.
No, they are merely they are on interim. It does not mean that.
My lord, we have also sent our requisition on that date, and that was fixed 22/24. It was listed, my lord. Then we have sent requisition 21/2, my lord. We have sent our requisition from our office, my lord.
But merely sending the requisition will
My
not do. So again and again, same matters, we have to take it up. Mr. P. Sharma learned additional PP submits that he has not received the case diary and press for listing the matter. When?
27, my lord.
27. Till then, interim order dated 20th to 2024 stands extended.
Item number 35.
May I plead your say? Madam, decision 438 in application, madam, there are two numbers of accused petition on madam. And the matter, madam, relates to a land, my lord. Kindly fill the FIR, madam, that is page.
Yes, Sharma, here also you.
Received the CD, my lord.
Received
Here we have
the
received the case there, my lord.
Okay.
Page 15 is the FIR relevant portion, madam. May I read, my lord?
Page 15.
Page 15, relevant portion, my lord.
Yes.
Sir, with due regard, with the undertake like to state before you that one, that sir, the informant number 1 is a retired sub-inspector of police resident of the offense and locality. After serving about 37 years as a public servant of Assam Police, purchased a plot of land jointly along with the informant number 2, measuring 1 kata 6 acres covered by turn number so consideration amount of rupees so only from the power of attorney holders, namely Selim Ali of Satgaon and Himanshu Sharma of Borbari, height registered deal dated 15th October 2023. Para 2. That's thereafter myself and my friend namely Riaz Ali jointly filed an application for mutation for the same land in favor of our name. Accordingly, after complying all the procedures as a circle officer disclosed revenue circle issued an order dated thereby the same land has been mutated in our name. That's thereafter we obtained a copy of Jamabundi for on 21/11/2020 both of us the landowner paid revenue in connection with the same plot of land to the authority concerned. 5. That's after purchasing the land while we were processing for mutation, etc. At the same time, on first week of November 2020, the accused Ibrahim Ali with the instruction of accused number 2 and 3 landmark illegally grabbed approximately 10 acres of land out of 1 kata 6 acres of our land, and accused number 1 since the death he is forcefully and illegally residing in our land by constructing tin roof house by obtaining forged and fabricated land documents from accused number 2 and 3. This is the basic allegation.
Mm.
This is the basic allegation of accused number 1 and 3.
Mm.
That we have legal 2 and 3. So this is next, Your Honor, page number 19, Your Honor.
Mm.
This petitioners, accused petitioners, my lord, obtained 2 numbers of power of attorney, my lord, registered power of attorney, my lord, from my lord, registered owner Mukesh Rahman, my lord. In respect of my lord, 15 less 1 lakh 1 katha 15 lessers, and next is my lord 15 lessers. And this land has already been sold, my lord. Thereafter, another power of attorney holders, my lord, Selim Ali and Himanshu Sharma, obtain another power of attorney from the
Oh, who is the owner of the land?
Mukesh Rahman. Mukesh Rahman is the original owner of the land. He issued 3
So
numbers
this informant number 1 and 2,
My-
from whom they have purchased the plot of land?
from attorney holders, that is Selim Ali and Himanshu Sharma.
Hmm.
Already mentioned in the attorney in the
Hmm.
FIR, my lord. That is from the power of attorney holders, namely Selim Ali of Satgaon, Noapara, and Himanshu Sharma of Borbari.
Hmm.
So and so registered shall be dated 15th day of October 2023. My lord, quite of that, my lord, kindly go to page number 31, my lord. Annexure 4, my lord. The accused petitioner number 2, my lord, Hafiz Ali, my lord, already purchased the same plot of land, my lord, by making a agreement, Your Honor, from the attorney holder Selim Ali, my lord. Kindly go through, my lord. Here is the condition also there. Be it mentioned herein that we have not made any gift, mortgage, sale deed of the scheduled land to any other parties. If it is brought, then I will be punishable as per law, and the advance money will be refunded with interest. There is a condition, my lord. And this agreement was executed on 12/1/2021, my lord, very early on, my lord. And thereafter, my lord, these petitioners, my lord, due to some monetary problems, my lord, sold us said land by making an authorized agreement, and page 36, my lord. This petitioner.
Can a land be sold by
My lord, one after
authorized
another, my
agent?
lord.
Thing is that, my lord, we have agreement, my lord. One agreement holder can make agreement to another person, but sale deed will be executed by the registered power of attorney holder, Salim Ali, my lord. Next, my lord, 36 page, my lord, page 36. Hafiz Ali and Izaullah, these are the petitioners, my lord. Sold the said plot, my lord, page 37, my lord, Ibrahim Ali and Rukhsana Begum. Page 37, my lord. And Selim Ali and Himanshu Sharma already has taken a huge amount from the petitioners, my lord, earlier in the time of purchasing, my lord, by making the deed of agreement, my lord. Thereafter, my lord, these two petitions, due to some monetary problems, my lord, sold the said land, my lord, with consultation with the Selim Ali and Himanshu Sharma, my lord, to Ibrahim Ali and Rukhsana Begum. And Ibrahim Ali was also, possession was also handed over by Selim Ali to Ibrahim Ali 10 lessons land. Thereafter, my lord, without informing us, my lord, and Ibrahim Ali and Rukhsana Begum, said Selim Ali and my lord, Himanshu Sharma, my lord, attorney holder, sold the land, my lord, without informing and returning our money, my lord. To my lord, present informants, my lord.
Hmm.
I have already. Yes, my lord. Page 42, my lord. This was executed on 16/11/2023, my lord. Very later on, my lord. But till down, my lord, my money has also not been returned by Selim Ali and Himanshu Sharma, my lord. And Ibrahim Ali, my lord, already filed a civil dispute, my lord, that is pending against us also, my lord, and the original owner.
So how can you purchase the land while it was already mutated in the name of some
My
other
lord,
person?
my lord.
No, that was my lord on a mutation later on, my lord. We have purchased my lord on 12/1/2021, my lord.
Maybe,
And
but
mutation, my lord,
your deed is notarized only.
notarized, yes, my lord.
That can be executed at any point of time.
One agreement holder can make an agreement with other person also, my lord, with the consultation with the
No, no.
power of attorney holders, my lord. And already, my lord.
So when a retired person had purchased a
My
plot
lord,
of
my
land
lord.
and you have grabbed the land,
My lord.
grabbed the same.
No, we have not grabbed, my lord.
Mhm.
Ibrahim Ali grabbed the land, my lord. And he has already arrested, my lord. He is now in jail, my lord. And these petitioners have no any involvement, my lord, in the making of any documents, anything, my lord. We have also the power of attorney holders, my lord. Kindly pay
Statement of the Ibrahim also there, my lord.
maybe, my lord, Ibrahim under purchase, my lord. Since there are two existing agreements, my lord, but the Salim Ali depriving us, my
I
lord.
check my lord, Ibrahim.
Yes, depriving us, my lord, and without returning our money, my lord, sold the said land to the present informants, my lord. This is the violation, my lord.
So both of you were in hand in gloves with
My
Ibrahim.
lord,
Ali.
Ibrahim. my lord.
Thing is that, my lord, this is a civil dispute is also going on, my lord.
Maybe,
We are also
maybe,
contesting, my
maybe.
lord. So, and we will appear before the investigating officer, my lord. We have no any, my lord. We will appear definitely, my lord. We are a permanent resident of Guwahati, my lord.
Maybe.
Yes. Yes, my lord, there are two existing agreements, my lord. And violating those agreements, my lord, the Salim Ali and Himanshu Sharma sold the said land to
Heard Mr. T. Hussain, learned counsel for the applicants, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 438 CRPC is prepared by applicant Yazul Haq alias Yazul Haq and Hafiz Ali, who have been apprehending arrest in connection with Hatgaon PS case number 20 of 2024 under section 420, 468, 471, 384, 506, 34 IPC for grant of PSP. The above noted case has been registered on the basis of one information. Now, on the basis of one FIR lodged by two informants, namely Tamizuddin Ahmed and Riaz Ali, on Seven to 2024. The essence of allegation made in the FIR dated so and so is that the informants have purchased a plot of land measuring 1 kotha 6 lesser covered by Dag number 2157, Keras Patta number 1236 of Hatgaon Place by paying a sum of rupees 20,80,000 from the power of attorney holder, namely Salim Ali of Satgaon, Naupara, and Himanshu Sharma of Barbarisuk, Guwahati, by a registered sale deed on 5th of October 2023, and thereafter got the same mutated in their name and also paid revenue for the said plot of land. Thereafter, in the first week of November 2023, one Ibrahim Ali, with instruction from one Yazul Haq and Hafiz Ali, who are land grabbers, who are land mafia, illegally grabbed approximately 10 lesses of land out of 1 kotha 6 lasa of their land. And Ibrahim Ali has forcefully and illegally residing in the said plot of land by constructing one tin roof house and also obtained forged and fabricated land documents from Yazul Haq and Hafiz Ali. Mr. Hussein Learned Counsel for the applicant submits that the applicants are innocent and no one involved with the offense alleged, and that they have purchased the said plot of land in the year 2021 by executing notarized agreement, and that the matter relates to document, then they will appear before the court. They will appear before the IO and cooperate with the investigating agency, and therefore Mr. Hussein contended that the privilege of PRS bail may be extended to the applicant. Whereas Mr. B. Sharma, learned additional PP, has produced the case diary before this court and submits that the IO has collected sufficient incriminating materials against the applicant, and therefore Mr. Sharma has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also produced the case diary with the assistance of Mr. Sharma, learned additional PP. The case diary indicates that the IO has collected sufficient incriminating materials against the applicant. Investigation is going on, and extending the privilege of PRS bail at this stage will disturb the investigation.
My lord, one thing, my lord. Since one is civil matter is pending, we are unable to appear because of absconding, my lord. Only, my lord, think that may be considered, my lord.
But
One civil case, my lord, page 53, my lord, kindly.
maybe,
In the
maybe,
civil case, not necessary to appear personally.
No, my lord, we have to file, dear, my lord, our written statement, my lord. We are unable to file, my lord. Kindly, my lord.
in view of the
One
materials collected so far in the case diary, it cannot be said at this stage that the custodial interrogation of the applicants are not required in the interest of investigation. Their custodial interrogation appears to be indispensable in the interest of investigation, and therefore the petition is thus dismissed. Case diary be returned.
Deeply obliged.
38, my lord. This is in respect of the suspected Burmese superhero, my lord. My lord, in the meantime, my lord, leaving tendency of this petition, the petitioner has already got the Jimma of the superhero, my lord, detail nuts, my lord, by the order dated 26/2/2024. This is the order, my lord.
Polita?
এখানে। Petitioner is the owner, my lord.
Yes, Locker? So now he could not go to the police station to obtain the same in Jimma. That is your apprehension.
My lord,
So though you have been granted Zimma, you could not go to the police station and take the same into your custody
yes, my lord.
because of apprehension of arrest.
Yes, my lord.
Yes, so what is the stage of investigation, Sharma, Mr. Locker? No, Locker, this sound.
Only some senior witnesses statement has been recorded, Lordship. And Lordship, but I have not found that these articles has been sent for FSL, Lordship. That I have not found.
You do whatever you like, but whether his custodial interrogation is required or not, that is the question before the court.
The petitioner will cooperate, my lord.
Whether he has been implicated by any of the witnesses?
No, no.
No.
Only Caesar witness lordship, they have seen, they see the material lordship. Caesar
Whether the
witness,
driver was apprehended,
that is the lordship. And
Driver fled away, my lord.
fled away.
Yes.
Okay, heard Ms. S.B. Surure, learned counsel for the applicant, and Mr. P.S. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Paskram PS case number 11 of 2024 under section 120B 379 420 IPC. Read with section. No, IPC. This application under section 438 services prepared by applicant Abul Fazal Barvoya for grant of period bail. The above noted case has been registered on the basis of one FIR lost by one Sandramani Sinha, ASI of Police, Paskram PS. On 24/1/2024, the essence of allegation made in the FIR dated so and so is that during Nakaseking at about 7:30 p.m. on 24/1/2024, he has found one truck bearing registration number AS26AC 1382, which is coming from Algapur side towards Dholesar side. And accordingly, signal was given, but the driver managed to flee away with the truck. Therefore, they have apprehended, intercepted the same, and having checked the same, they found 33 bags of Burmese betel nut suspected to be of foreign origin. And accordingly seized the same in presence of witnesses. Ms. Chaudhary, learned counsel for the applicant, submits that the applicant is the owner of the betel nuts and he has filed a petition before the learned court below, that is the learned Chief Judicial Magistrate Hailakandi, seeking custody of the seized betel nuts, and by order dated 26/2/2024, the learned court below was pleased to release the seized betel nuts in the custody of the applicant. Ms. Chaudhary further submits that the applicant is innocent and no way involved with the offence alleged, and he is also ready to cooperate with the investigating agency. Therefore, it is contended to allow the petition. On the other hand, Mr. P.S. Locker, learned additional PP, has produced the case diary before this court and fairly submits that the materials collected so far in the case diary are inadequate to show the complicity of the applicant with the offence alleged, as the witnesses so far examined by the IO are all Caesar witnesses. But having heard the submission of learned advocates of both sides, I have gone through the petition, the documents placed on record, and also for the case diary with the assistance of Mr. Sharma, Mr. Locker, and also there is the order dated 26/2/2024 passed by the learned Chief Judicial Magistrate in Paskram PS case number 11 of 2024, by which the learned court below has released the seized 33 bags of betel nut in the custody of the present applicant. Having considered the submission of learned advocates of both sides and also considering the materials collected so far in the case area, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with Pascam PS case number so and so under section so and so, he shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition is shall not leave the jurisdiction of CJM Hailakandi without prior permission. Pasgram is in Hailakandi?
Yes.
Thank you.
Apply.
And with item number 24.
Manipur.
Manipur, yes. Yes, police station.
And what is CS submitted, Lordship? CS number 167, dated 31/10/23.
3110
10/23,
under section.
under section 9, 10, and 11 of PCMA. Read with section 376 IPC. And against this person, Nobir Ahmed Hussain, he is Nobir Hussain.
Okay, heard Mr. MS Ahmed, learned counsel for the applicant, and also heard Mr. E.S. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Manipur PS case number 180 of 2023 under section 376 IPC, read with section 6/7 of the POCSO Act, read with section 9, 10, 11 of Prohibition of Child Marriage Act. This application under section 438 services prepared by applicant Nobir Hussain for grant of pre-arrest bail. The above noted case has been registered on the basis of one FIR lost by one. FIR is a page number.
Manipur PS case number 180.
On the basis of one FIR lost by one Kamal Kumar Nayak on.
Lordship, one more section is there. Lordship.
Pardon?
Read with section 6 and 17 of POCSO is also there. Lordship.
Okay.
Yes, it's 76.
Kamal Kumar Nayak on 3/10/2023. The sense of allegation made in the FIR dated so and so is that one Nobir Hussain of Blaze 5 number Bhandara under Manipur police station forcefully got married with one 17 years old daughter, namely Srimati X of one Auza Kuroni Mia. And she has been carrying pregnancy. And also taking medical advice for golf facilities. Mr. Ahmed, learned counsel for the applicant, submits that as per his information, the IO has completed investigation and submitted search sheet. And that the applicant was granted the privilege of interim PRS bail by order dated 22/11/2023. And pursuant to the said order, he had appeared before the IO and cooperating with the investigating agency. And therefore, it is contended to make the interim order dated 22/11/2023 absolute in the same terms and conditions. Mr. P.S. Locker, learned additional PP, also confirmed that investigation has already culminated in submission of charge sheet, being charge sheet number 167 dated 31/10/2023 under section 9, 10, 11 of Prohibition of Child Marriage Act, read section 376 IPC, read section 6/17 of the POCSO Act. Since charge sheet has already been submitted after completion of investigation, this court is inclined to dispose of this petition by directing the applicant to appear before the learned court below on or before
4th of April.
and to apply for regular bail, and in the event of filing such an application, the learned court below shall consider the same in accordance with law. Till then, interim order dated 22/11/2023 stands extended.
Item number 38.
May please, Your Lordship. Lordship, 438 application, and I'm owner of the vehicle, Your Lordship. As per the fire, that vehicle has been used to store 3 numbers of cattle, Your Lordship. Section 380 is there, Your Lordship.
So CD received, Local?
CD received, Lordship.
What is the stage of investigation?
Lordship, some evidence has been collected, Lordship, and the vehicle was intercepted, Lordship, while carrying, loading that 3 numbers of cows, Lordship. And thereafter, the villagers came and intercepted the vehicle, Lordship.
So the present applicant is the owner of the
Owner of the
vehicle. What was his role?
All evidences are regarding that those persons who are carrying, actually at that time others are played away, and all evidences are regarding that loading of the vehicle, stolen cows. Lordship.
That's all right, but is there any material against the present?
Regarding that, but I have not found anything, Lordship, who directly implicates him, Lordship.
Heard Ms. G. Bada, learned counsel for the applicant, and also heard Mr. P.S. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Sunapur PS case number 14 of 2024 under section 380 IPC. This application under section 438 is prepared by applicant Saidul Islam for grant of the arrest case. The above case has been registered on the basis of an FIR lodged by one Corona Rajvamsi on 30/1/2024. The essence of allegation made in the FIR dated so and so is that on the intervening night of 30/1/2024 at about 3:30 AM, some unknown culprits entered into their house premises and committed theft of 3 numbers of cattle. And tried to load the same in one vehicle bearing registration number AS01FZ 5183. And thereafter some person who were carrying bricks in a vehicle noticed the same and raised alarm, and then the culprits fled away along with the vehicle. but having been obstructed the road by the driver of the vehicle carrying the bricks, the culprits left the vehicle and fled away. Ms. Bora, learned counsel for the applicant, submits that the applicant is the owner of the vehicle bearing registration number AA01FJ 5183. And that he is no way involved with the offense alleged in the FIR and he is ready to cooperate with the investigating agency. And therefore it is contended to allow this petition. Whereas Mr. Locker learned additional PP has produced the case hearing before this court and submits that the materials collected so far in the case area are inadequate to show complicity of the applicant with the offense alleged in the FIR. Therefore, it is having hard. But in view of the materials collected so far in the case area, and also in view of the stage of investigation, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. There's a 50,000 with last condition. CJ. From which place this is?
Sonapur Police Station.
Kamrup. Kamrup.
Item number 39.
Item 39, we have not received the city list.
Mr. P.S. Locker learned additional PP submits that he has not received the case aid. Accordingly, it is provided that Mr. Locker shall produce the case aid before this court or
Second of appealers. Second,
short date.
28 lords.
Here interim is not
20
granted.
28.
Item number 40.
Second verification of it. Lordship has already earlier rejected it.
So case aid received here.
City received lords.
So what is the ground for filing this second application?
Lordship only 41A notice, Lordship. That has not been issued to me till date, Lordship. That is the only.
41A notice that can be served at any point of time.
Lordship, till now, Lordship, no 41A notice has been served. Therefore, Lordship, I have to file this second bail application before this court. So that.
Yes, Locker.
Was it 41 in notice regarding materials are dear lordship? Earlier rejected materials are dear against him lordship. Regarding 41 in notice, accused cannot come and say lordship that as 41 in notice is not served upon him. So lordship, he may be allowed to go on bail lordship, interim protection lordship. Because also if police thinks that his arrest is required lordship, then police will arrest him lordship. 41 and one notice will not give to him lordship. Then police will say, police will submit a checklist lordship, mandatory checklist as per Ernest Kumar judgment lordship. Police wanted his arrest lordship. His arrest is warranted lordship. If his arrest is not warranted, then only 41 notice will be given.
So the question is, can the court grant anticipatory bail for non-compliance of section 41A service? In the case of Satendra Kumar Antil versus CBI, it is settled that in the event of arrest and non-compliance of section 41A accused will entitled to grant bail.
In case of
Entitled.
bail lordship, they can claim lordship. In case of regular bail, they can say lordship. Even though lordship, they can take a plea lordship that I have been already been arrested, but 41 notice I have not been served upon me lordship. But he is not
No,
yet
that's
arrested.
why the question before the court is, can the court grant bail? Anticipatory bail for non-submission of 41A notice to him? Is there any proposition?
Lordship, I have not found any
Then-
proposition till now. But Lordship, I am not in fact praying for anticipatory bail, though second bail application has been filed. I am just praying your Lordship may direct the concerned investigating officer to comply the Anish Kumar direction. That's it. Because in
No,
coordinate bench-
for that direction,
Court cannot.
Lordship, coordinate bench led by Justice, retired Justice R.K. Fupan, has once a similar direction in a case where second bail application was filed and no 41A notice was served. That case was under section 8 of POCSO Act. Here 379, 3 years punishment, Lordship. May I place that order, Lordship. And Anish Kumar, Lordship, if I may allow to submit, and if I have read correctly, Anish Kumar says that within institution of 2 weeks, the 41A has to be issued, or if it is not issued, then the superintendent of police has to record reasons why the delay is occurred while for not issuing 41A notice. And the learned magistrate of the concerned jurisdiction, the IO has to submit a report within 2 weeks of the institution of the case. That is the guidelines provided.
So, you saw any proposition that for non-compliance of section 41A,
Lordship,
court can grant anticipatory bail to the accused,
Lordship.
or court can direct the IO to serve notice.
To my understanding, lordship, 41A notice, what he is submitting lordship, that petitioner is submitting lordship, that 41A notice, why it is not given within 2 weeks, that has to inform. Lordship, no lordship, why 41 notice has been given to him and why he is not being arrested, that has to be informed to the court lordship. Why 40, instead of arresting him, why he has been allowed to go by giving 41A notice, that has to be informed to the court lordship, to my understanding lordship. Otherwise, lordship, in each and every case, lordship, everyone will come, lordship, 41 notice is not given as it is 7 years below, lordship. Then police cannot even catch a theft also, not know anyone, lordship. Most of the sections are below 7 years, lordship. 7 years, 7 years, lordship. Even for arresting a person who is involved in theft, lordship, that has to be, police has to come with 41A notice, lordship. This has to inform the court why he has been allowed to go.
No, here nothing has been discussed, only it is directed that I shall serve notice. But
11.5, I think that's
is
11.
it within the ambit and jurisdiction of this court to ask the IO to comply the provision of section 41 SCRPC?
Lordship, the police, it is the power of the police, lordship, whether he wants his in the arrest or not, lordship. The section says that like
So
that,
let
lordship.
us fix another that you satisfy the court.
Lordship.
Well, you saw the provision,
Lordship.
definitely will consider your prayer if there is any provision. As agreed by learned advocates of both sides, registrar list the matter on when Sharma or Mr. Locker.
That's it.
Chip. 27 or so. 28 or so.
28.
28.
28.
It will be 18.
Item number.
Till then, case will be retained. Not a case for the applicant on call, raise the matter after 1 week.
Item
In 45?
45.
On some other day may be taken up, my lord. I have
Why?
Today I have taken a step, my lord.
Only today.
I forgot to take a step.
Mr. A. Rahman, Learned Counsel for the applicant submits that he has taken step upon respondent number 2 only today and press for listing the matter after 1 week or 2 weeks.
2 weeks.
After 2 weeks, there is accordingly allowed. CD received, Mr. Locker?
45 CD not received. 45 CD not received.
Not received.
CD not
On that day, Mr. Locker shall produce the case diary before the court.
received.
Bless you.
So here in this case, Lordship, counsel for the forest department has come, Lordship, and they told us that, Lordship, as it is registered by the police case, it is registered under PS case, Lordship, Vasishtha PS. So we can call for a CDO. Only the section is there is a added section. Section is there, Lordship. Special Act has been incorporated. So if they will only investigate the case wherein the forest lost the complaint, Lordship. So as this is Vasishtha PS,
So you have not called for the case diary.
we have already called for it is not received, Lordship. So Lordship,
Mr. Locker, Learned Additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Locker shall produce the case diary before this court on
Lordship,
sorted 22nd.
Time being item number 19.
Yeah, Lordship, I tried to go through, Lordship, but Lordship, only the accounts number are available in the statement, Lordship. So it cannot be said, Lordship, that whether whose account it has been transferred, Lordship. And I tried to go through the whether there is any specific I will not, Lordship, that this account number is so and so. That is also not available in the city, Lordship. So, Lordship, I cannot say, Lordship, from the statement, Lordship, I could not ascertain, Lordship, that he from his person, this person's complainant person's money has been transferred to this person directly.
So for how long you are behind the bar?
21 days.
But the allegations are serious in nature.
It's a respect for running main accused is Minajuddin Loskar, my lord.
Your name is also there in the FIR.
Nur Ahmed Barhuya, not in FIR, forwarding report. In fact, there is no name is in FIR.
FIR may not be there. FIR may not be. In FIR may not be his name may not be there. But subsequently his
As per my
involvement is there.
lord, from Minajuddin Loskar, my lord, he is the main culprit. As per my lord forwarding. One Abdul Haim Mazhar Bhuya also. In his account, my lord, money was transferred.
So they have also another case.
This my lord in 2017.
There.
2017.
So it means that you were habituated to the offense.
My lord, I am not in this case, my lord. My lord, when accused Faiz Ahmed was dealing port SIM card 16. The port SIM card collected.
Okay, heard Mr.
M. Golita.
Learned Counsel for the applicant, the accused, and also heard Mr. E.S. Locker, Learned Additional PP for the state respondent. This application under section 439 services referred by accused Nur Ahmed Barhuya, who has been languishing in Jail Hazard in connection with Patsala PS case number 81 of 2023 under section 379 IPC, read with section 66C, 66D of the IT Act for grant of bail. It is to be noted here that above noted case has been registered on the basis of an FIR lost by one city. What is the name of the informant? Konak Sundar Das.
Yes.
On 26/10/2023. The essence of allegation made in the FIR dated so and so is that he has been maintaining one account at State Bank of India, Patsala branch. And since 12/10/2023 till 23rd/10/2023, some unknown persons have withdrawn a sum of rupees 3,41,700 from his account. Mr. Kolita, learned counsel for the accused, submits that the accused was arrested on 22/2/2024, and since then he has been languishing in jail as of for last 21 days. And that he is nowhere involved with the offense alleged in the FIR. And the main culprit of the offense is one Minhajuddin Laskar, and he has already been arrested, and that the accused is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. Locker, learned additional PP, submits that the IO has collected some materials in support of the allegation made in the FIR. And therefore, Mr. Locker has opposed the petition. But, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Locker, learned additional PP. The case diary indicates that some materials have been collected by the IO in support of the allegation made in the FIR. But it also appears that some progress has been achieved by the IO in investigation of the case, and the main culprit has already been arrested. And the present accused is languishing in jail as of for last 21 days. And given the nature of accusation and the punishment prescribed for the same, and balancing the same against the period of detention, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned judicial magistrate.
Bozale.
Bozale, Patsala Bozale, the accused being arrested.
I'm being item number 30.
So here I have received the CS number also, CS number 14/24 under section 365 IPC, read with section 4 of POCSO, and against this person, Pranab Sarkar.
My lord, I was on interim and I appeared.
This para number 1, 2, and 3. Ms. Barua, learned counsel for the applicant, submits that this court fight order dated 16/2/2024 was placed to grant interim protection to the applicant. And pursuant to the said order, the applicant had appeared before the IO and cooperating with the investigating agency, and therefore Ms. Barua contended that the interim order dated 16/2/2024 may be made absolute in the same terms and condition. Whereas Mr. P.S. Locker, learned additional PP, submits that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted search sheet, being search sheet number 40 of 2024. 2024, dated 25/2/2024 under section 365 IPC, related section 4 of the POCSO Act. But in view of the submission of learned advocates of both sides, this court is inclined to dispose of this previous bail application by directing the applicant to appear before the learned court below on or before
1st April.
and to apply for regular bail, and in the event of filing such an application, the court below shall consider the same in accordance with law. Till then, interim order dated 16/2/2024 stands extended.
Left, my lord.
এইকেইটা আগতে এখন বুকিং দেখা নেকি? এডভোকেট আছে নেকি?
My lord, in this case, it appears that notice has been out. 28.
So
Notice has
this
been-
item number 18,
No,
Abu Tahir.
28.
Acha.
Notice has been served upon the informant that is there in leg M, left side. My lord, our prayer is this person is 72 years old man. There is a half bighas of cash land. He is a teller also. There is half bighas of cash land. I am occupying that plot of land, and the informant also wants to occupy that land. That is our clear case. I have categorically mentioned in para 4 of my petition. Now the incident happened on, my lord, 26/12/23, but she filed case much later. That is afterthought, my lord.
What is this Mike? What is the number?
Section number 2/24, madam. Dated 31/1/24
Under section?
under section 448/506 IPC. He reduced section 4 of POCSO, madam.
You go and appear.
My lord.
Some protection provided.
Heard Mr.
My lord, my one another submission is this person is suffering from various illness. He's 72 years old, so these things may kindly be observed, and Planet Court may consider this aspect also.
Which aspect? No, we cannot direct to consider those
No,
aspects.
the
You
observation-
produce all the relevant
No,
documents
before
before the court below.
madam.
So that is beyond our purview that we will direct the court below to consider
Now,
a particular application in a particular way.
my prayer is only to observe all this.
No, 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 no. Heard Mr. M.U. Mahmood, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Jogi Gopa PS case number 01 of 2024 under section 448 506 IPC, reduced section 4 of the POCSO Act. This application under section 438 services prepared by applicant Azahar Ali alias Ukko for grant of PRS pay. Notably, the above mentioned case has been registered on the basis of one FIR lodged by one
Respondent number
Saliha Khatun on 1/1/2024. The essence of allegation made in the FIR dated so and so is that Mr. Mahmood, the age of the victim girl is below 8 years.
My lord.
So this petition itself is not maintainable.
Actually, my lord, this is not correct. She is nearly 16 years, as I have been told. But only to capture the land and to get me away from the land. So, at 72 years old man, my lord, how Lordship may consider his physical, besides this, he is suffering from various illness, certificates are there. So
My lord,
only to grab the
page-
land, which is in.
Page 12, my lord, particular, my lord. Page 12, my lord. FIR, my lord, regarding what is done. Page 12, my lord.
Those are actually.
Lordship may also see paragraph 4 of my petition, and that is the case.
No, that is
Not
your
necessary.
defense, so we are not supposed to consider that aspect at this stage. Huh? That on 28/12/2023 at about 2 p.m. accused Azahar Ali subjected her daughter Shrimati X, name withheld, is at 8 years, to sexual harassment. And while her eldest daughter raised alarm, then the accused fled away. And she found her sister in naked condition. Mr. Mahmood, learned counsel for the applicant, submits that the applicant is innocent and falsely being implicated with this case in connection with a plot of land, and that he is a person of 71 years old and suffering from various ailments, and that he will cooperate with the investigating agency, and therefore Mr. Mahmood contended to allow the petition. Whereas Mr. B. Sharma, learned additional PP, has submitted that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted search sheet, being search sheet number 2 of 2023. 24, yes, dated 31/1/2024 under section 446, 506 IPC, read with section 4 of the POCSO Act. And further, Mr. Sharma submits that the offenses are serious in nature, and therefore Mr. Sharma has contended to dismiss the petition. Having heard the submission of learned advocates of both sides, this court is, and also considering the fact that search sheet has already been submitted before the learned court below, this court is inclined to dispose of this PRS bail application by directing the applicant to appear before the learned court below and to apply for regular bail. In the event of filing such an application, the court below shall consider the same in accordance with law. On or before, when?
3rd April.
3rd April. Till then, in the event of arrest of the applicant in connection with case number so and so, he shall be released on interim PRS bail till his appearance before the learned court below. On his executing a bond of rupees 50,000, which once you return like amount to the satisfaction of the arresting authority. And the above privilege is, however, subject to the following 3 conditions. Number 1, he shall appear before the Court of Learned Special Judge POCSO, Gwalpara, on or before. And
Yes.
Acha. Learned additional session judge POCSO Abhayapuri. No. Learned special judge POCSO Abhayapuri. And to honor before so and so. And number 2, he shall not leave the jurisdiction of learned special judge POCSO Abhayapuri without prior permission.
Hello. Time being item number 18.
May it please your lordship. 439 application, my lord. Your lordship will find the FR at page, my lord, 10, my lord. Relating to, my lord, cattle, my lord. And I am behind the bar for 39 days as on today. The diary was called for, my lord, in the morning.
Yes, or no?
CDC, my lord.
So what is the stage of investigation?
Investigation is going on, my lord. Some of the accused person is yet to be arrested, my lord. Some of them were arrested, my lord. And he,
No, but so far this present accused is concerned, what is the position?
my lord.
You are behind the bar for 39 days.
Exactly 39 days as on today, madam. And my lord, 41A notice was not also served, my lord. On me, madam.
Heard Mr. N.J. Dotto, learned counsel for the accused. And also heard Mr. B. Sharma, learned additional papers for the state respondent. This page number 25. Para number 2. Two and 3. It's 439. This is 438. Mr. Dotto, learned counsel for the accused, submits that the accused was arrested on
5/2/2024. Page 14.
Five to 2023. No, 2024, and since then he has been languishing in jail as well. For last 39 days. Who was he?
My lord, so far, my lord, the forwarding report says, my lord, I am a middleman who passes the car, my lord. Page 16.
Seven, seven.
Seven, serial
Seven.
number 7.
Reason for arrest 7.
My name is Abu Tahir.
And that he is no way involved with the offense alleged in the FIR, and his only rule, alleged rule was that he received money wrongfully from the cattle smugglers for safely passing the cattle loaded vehicle to Meghalaya. And that the accused is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. Arjay Barua, learned additional, Mr. B. Sharma, learned additional PPS produced the case study before this court and submits that IO has collected sufficient incriminating materials against the applicant. No, against the accused. And therefore, Mr. Sharma has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition number documents placed on record and also perused the case that with the assistance of Mr. Barua or Mr. Sharma, learned additional PP. Right, the case that indicates that I has collected some materials in support of the allegation made in the FIR. But it appears that the IO has achieved substantial progress in the investigation of this case. The accused is behind the bar for last 39 days, and balancing the same against the nature and gravity of the offense, his further custodial detention seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned chief judicial magistrate Kamrup and the accused be annulled and bail. Is there a return?
I am obliged.